The lawsuit pitting Governor Roy Cooper against Lieutenant Governor Dan Forest is scheduled to head to a court next week, and the governor fired his shots in the legal case today. Joining us for reaction to Governor Cooper's contribution to the Forest v. Cooper lawsuit is Jon Guze. He is Director of Legal Studies at the Locke Foundation. And Jon, this is a suit, Forest v. Cooper, that has to deal with COVID-19 executive orders. And what Dan Forest, the lieutenant governor, is looking for is a temporary restraining order to block several of the COVID-19 executive orders. So the documentation that we saw from Governor Cooper today is basically dealing with reacting to the request for a temporary restraining order and saying, no, you shouldn't have one.
That's right. That's all this is. It's just a preliminary, a very early motion, a temporary restraining order, which even if granted, would only last until there'd be a proper hearing on. I presume that the lieutenant governor has also asked for a preliminary injunction, but this would stop the enforcement of the orders even until the court could decide on its motion for a preliminary injunction. So it's a very temporary preliminary motion.
Now, I want to talk to you about some of the specific statements that Governor Cooper makes in the introduction to his filing. One of them, he says that the claims from the lieutenant governor stand no chance of success on the merits. When you saw that, what did you think?
Well, here's what I think is interesting. The last time the governor had to respond to a similar challenge in which there was a motion for a preliminary injunction, he simply brushed it aside. He said, this should be decided under what's called rational basis review. And when it's rational basis review, I don't have to bother with evidence. I don't have to bother with arguments. You should defer to me as a co-equal branch of government. And if I say I need to do this, you should just accept that. He didn't do that here. He provided a lot of evidence about the nature of COVID, what he's done, why it's necessary, and so on and so forth. So I just think it's interesting that he learned his lesson last time, and now he's going to make his case of why this isn't going to go forward on its merits. It's certainly not that simple, far from it. The ultimate question is how much can the governor do in an emergency without concurrence from the Council of State? That's a difficult, important question. You can't just brush it aside. At least I don't think you should be allowed to brush it aside. And none of the evidence he presents here is a slam dunk, according to which when this ultimately gets to the Supreme Court will agree with him. I'm looking forward to it, but it's a long way off before we'll find out how the courts interpret that statute.
We're going to get back to this issue of concurrence in just a bit, but I want to tackle a couple of other things the governor said that seem to have more of a political slant than legal slant. One, he disputes the lieutenant governor's assertion that this is a complaint about process, saying, look, the lieutenant governor has criticized me and everything I've done on this. So it rings hollow for him to say that this is just about the process and not about the actual substance of the orders. He also says, the governor in this legal filing, that the lieutenant governor's claim is divorced from the reality of the COVID-19 pandemic. Pretty harsh words in a legal filing.
Yes, and as you say, I think those are mostly political, especially the first of these. I mean, it doesn't really make any difference whether the lieutenant governor approves or disapproves of the specific orders. If the orders were illegal, they're illegal. That's the claim that the lieutenant governor is making. So I think you're right. This is more political grandstanding than anything else.
Now, after the politics, we actually get to more of the legal pieces of this, and I want to tackle a couple of them. One is that the governor says that the lieutenant governor errs in saying that the governor should not have the opportunity to coordinate a statewide response to this emergency, basically saying that the parts of the lieutenant governor's complaint that said that some of these actions should be left to local governments, that misses the boat, and that in a case like COVID-19, that there is a need for a coordinated statewide response and that the governor has that power. What do you think about that argument?
Well, there's two parts to it. One is the question of, is there a need for a statewide response? In other words, is it the case that local authorities, municipalities and counties couldn't have handled this on their own? That's a factual question, really. And it goes to the heart of this whole case, because what the governor's claim to have the power to do some of the things he's done, like lockdown orders, like forcing businesses to close, he's only able to do that without council of state approval if he finds that local efforts along these lines are insufficient. Insufficient being the exact word that's used in the statute. So the question is going to ultimately be, would local efforts have been insufficient, or were they insufficient? That's something the governor will have to prove when the time comes. I'm sorry, Mitch, I've forgotten the second part of your question there.
Yeah, the idea was that basically whether the lieutenant governor errs by saying that Governor Cooper doesn't have the authority to have a statewide response. He basically is saying, no, something like COVID-19, you need a statewide response. You can't just leave it to the local governments.
Well, it's a factual question. And, I haven't seen anywhere yet where the governor has really laid out. I mean, supposedly he's supposed to make a finding about this, and I haven't seen him lay out how he made that finding. There is some material in here, which is the first we've seen. And I'll just say in passing, one of the nice things about this response by the governor is, unlike his previous one, this is giving us a preview of the arguments he'll ultimately make if and when this gets to the Supreme Court. But he's going to have to do a lot more than he's done here. And he will, no doubt, bring forward experts and evidence to show that local efforts were insufficient. But that's not something he can simply assert. It's a factual question that he's going to have to prove.
We've already mentioned that one of the key issues here is whether the governor is required to put any of these executive orders that he's made in front of the Council of State, the other elected statewide executive branch officials, for their concurrence. And in the introductory section of this response, the governor says that the lieutenant governor is arguing that he supposedly must seek the Council of State's concurrence, and then basically brushes that off, saying no, other parts of the State Emergency Management Act make that not a qualification that I have to deal with. Do you think that he addresses this in a sufficient way, or is this going to be something that Lieutenant Governor Dan Forest might have a good case to pursue?
Well, I think the Lieutenant Governor will have a good case to pursue if and when this gets to the Supreme Court. On the other hand, we're just looking here at a motion for a temporary restraining order. The standard is much lower, and one basis on which the judge could make the decision is simply by weighing the equities here. And he's got, on the one hand, what the governor claims is a statewide emergency. Nothing like this has happened in more than a century. And on the other hand, we've got the question of whether he's exceeded his powers under a statute. I can easily see a court deciding, well, when I weigh these two things together, I think dealing with a statewide emergency is more important than getting a very swift answer from me about the facts in this case. So I'm going to deny the motion for a temporary restraining order. That said, though, I don't think what he's provided here is going to be sufficient in the long run. He'll have to do much better.
And in fact, you forecast one of the last things I was going to ask you about, and that was Governor Cooper saying after the rest of his arguments that the court should rely on the balance of equities, and that in his estimation, that if you provided the relief that Lieutenant Governor Forest is looking for, that could cause irreparable harm. And so that was why the governor says this balance of equities would weigh on his behalf. A couple other things.
I think that's probably the strongest argument in the whole response here. I think that is a pretty strong argument to make to a judge under these circumstances.
I want to touch on a couple other things before we wrap it up. One of them is, you'll remember from our earlier conversation on this, we talked about the lieutenant governor using some language and an argument that we hadn't heard before, and that is that under the quarantine provisions that the governor seems to have been using, he should have been relying on the health director, Dr. Mandy Cohen, and going to court to make sure that any quarantine that was put in place would extend beyond longer than 30 days. Basically, the governor in this response says, my orders are generally applicable, so it's not even a quarantine. This whole thing is baseless. What do you think?
Yes, well, that's a good question, and it's not what I've really thought about. I just haven't studied that part of the statute book, but I think, I don't know, Mitch. I can't answer that, but I will say this. I think it's going to be very interesting to see how Judge Gale rules on this, given that the last time this came up, he granted a preliminary injunction. And this shows that the governor is now taking all this much more seriously. I wish he'd done this from the very outset and made a point of explaining what he was doing and justifying it. And of course, what he should have done is gotten the support of the Council of State right up front, all along. We'd be in a much better place as a state right now if he'd done that.
I want to touch on one more issue before we wrap up, and that is talking about something you and I discussed earlier. I asked you whether you thought Lieutenant Governor Dan Forest had standing to make this. You know, that a case can't go forward unless the plaintiff has the actual legal standing to make the case. Governor Cooper, in his response, says, no, Dan Forest, regardless of everything else, he doesn't have standing as one member of the Council of State. And in fact, Governor Cooper tries to make some interesting observations of the fact that no other member of the Council of State joined the suit. Governor Cooper is saying that one member of this multiple member Council of State doesn't have the standing on his own to make this suit. So whatever else you think about any of the arguments, Lieutenant Governor Dan Forest is going to lose this case on standing.
Well, parties in these kinds of hearings always raise a standing argument. That's just pro forma. This is an interesting one, and I don't really know, haven't thought about it enough to have a strong opinion about it, but I think it's significant that what the governor cites for precedent here and support is a Supreme Court decision from 1997. He's not citing any statutory law. He's not citing any case law from North Carolina. So I would say at best, this is probably a very open issue and not one that I would think would succeed and would successfully deny standing. But there could be a case to be made. It's just going to take time. It hasn't been well developed yet in the papers.
Well, as we wrap up, I'll give you a chance to give a final thought on this. But my suspicion, based on what we've talked about, is this is fairly early on in the process, and because we're dealing with a temporary restraining order request, not the full lawsuit, that all of these arguments have yet to be fully developed, and we could see a heck of a lot more in terms of arguments from both sides before this thing is finally resolved.
That's right. And what's interesting about this, all these, I think we're going to see this with all the challenges, they get bogged down in these motions. And that really works in the governor's favor. The longer he can push these motion processes along and keep it tied up at this stage, the longer we'll have to wait to find out who wins on the merits. Now, for the bowling proprietors that we talked about last time, that could be the kiss of death. They can't reopen. They may be gone by the time this case reaches the Supreme Court, in which case it'll probably be moot. From the lieutenant governor's point of view, I've been thinking about this ever since I started reading this. I don't know what's working in his favor, whether he cares or whether this is mostly a political maneuver. I don't know. But from my point of view, and I think from the point of view of the people of North Carolina, it's a shame that we have to keep waiting under these circumstances to find out exactly what the governor's powers are under the Emergency Management Act. And I'd like to say one more thing about that. The fact that we're in this position shows that the Emergency Management Act needs to be revised. The General Assembly needs to go back and make it clear exactly what their governor can and cannot do without Council of State concurrence.
Well, the lieutenant governor who filed the initial complaint is going to have a chance by the end of this week to respond to Cooper's response. Then all the parties head to court on Tuesday, August 4th. So this is an ongoing case, and we know that as it continues, we're going to consult once again with the John Locke Foundation's Director of Legal Studies. He is Jon Guze. Jon, thanks for taking the time.
Thank you, Mitch.